Hello doctors, I'm Dr. Chris Rapoff of QME Continuing Education, and welcome to this week's Case Law Update. Today's case deals with the amount of an applicant's disability award being drastically affected by an appeals judge's decision that the original workers' compensation judge's ruling was erroneous. Why do you ask? Well, the apportionment conclusion in this case didn't qualify as, wait for it, substantial medical evidence. Here we are again. In this case, the applicant attorney argues that the basis for the apportionment in the original ruling lacked evidence to conclude that apportionment should even be considered. So, did something change during the evolution of this case to give the appeals board a reason to overturn the original apportionment decision? Let's take a look. In the Amaro versus the County of Ventura Sheriff's Office, we have an opinion and decision after reconsideration by the appeals board. Here, the applicant seeks a reconsideration of the findings and award that was issued by the Workers' Compensation Administrative Law Judge in 2021, where the judge concluded that the applicant sustained an injury arising out of and occurring in the course of employment, typical AOE-COE. And the injuries were involving his back and psych while he was employed by the County of Ventura Sheriff's Office from December of 2008 through September of 2018. And they concluded that the injury caused a 23% permanent disability after apportionment. Now, the judge originally ordered that the 2020 report from the primary treating physician, who was an MD, be admitted into evidence, and he found that the report was not substantial evidence as to the issue of apportionment. So the applicant contended that the trial record does not contain substantial evidence that supports the finding of apportionment, and that the CT injury caused a 45% permanent disability with no apportionment. Some background here. The applicant claims that the injury to his back and psych were while he was employed by the defendant as a cook during a period of 2008 to 2018, a period of 10 years. An orthopedic MD QME evaluated Mr. Amaro in 2019, 1 year later, and the QME examined the applicant, took his history, and reviewed the medical records of treatment that the applicant had received during a period from September of 2018 through December of 2018. The QME assigned a 5% whole person impairment for the applicant's lumbar spine condition. And regarding apportionment, here's what he stated, quote, apportionment is indicated in this instance in the 3% of his 5% impairment is secondary to a non-industrial cause and 2% due to the aggravation which could reasonably be consistent with his described work activity. In March of 2019, his primary treating physician performed his initial evaluation of Mr. Amaro. And Mr. Amaro underwent a course of treatment by the PTP. And in his March 2020 permanent and stationary report, the PTP diagnosed Mr. Amaro as having lumbar spine spondylolisthesis, which you recall is a forward slippage of the vertebra, of L5 over S1. Also, some spondylolysis, which was a stress fracture of the vertebra, and lumbar spine radiculopathy. Now, regarding the issue of apportionment, here's what he stated. Based on the available information and with reasonable medical probability, the patient does indicate that he sustained a slip and fall accident sometime in 2010, along with a continuous trauma injury both to the lumbar spine. Based on the above, I would apportion 50% to the slip and fall accident and 50% to the continuous trauma injury. So that was the original conclusion by the PTP. However, he was provided a transcript of Mr. Amaro's 2019 deposition. And then he changed his prior opinion regarding apportionment, and he said, following a review of the provided deposition and revisiting the patient's provided history at the time of his initial examination in 2019, I'm led to reconsider my opinion regarding apportionment provided in my 2020 report. And now it's apparent that the patient, Mr. Amaro, recovered following an earlier work injury in approximately 2010. And he essentially performed his usual and customary duties for approximately 2 years before he experienced a recurrent back pain. But during this time, the patient, Mr. Amaro, had reported that his occupational duties required prolonged standing and walking and regular bending and stooping, squatting, lifting and carrying up to 40 pounds. So given these factors, it is with reasonable medical probability that the patient's recurrent low back pain after 2 years of apparently being symptom-free was industrially caused by the patient's CT injury. Given this, a permanent and stationary report is amended regarding the issue of apportionment. Based on the factors that he has discussed, the patient's lumbar spine impairment and disability was caused 100% by the work-related cumulative trauma injury in September of 2018, with no basis for apportionment to the other factors. So it's very interesting. He changed from 50% to 100% based on the gentleman's deposition outcome. The parties proceeded to trial in February of 2021, and the appeals board gave their response. Now, first of all, the appeals board began by defining what the apportionment orders are. And they say in order for a medical report to be substantial pertaining to the issue of apportionment, the reporting physician first has to identify the approximate percentages of permanent disability due to the direct results of the injury and the approximate percentage of permanent disability due to other factors. In addition, the physician has to explain the nature of those other factors, the how and why those factors are causing permanent disability at the time of the evaluation, and how and why those factors are responsible for the percentages of disability that was assigned by the physician. So it's apparent that they must do twofold here. They continued by addressing some of the specifics of this case. And they said that both the QME and the primary treating physician's initial reports stating that in February of 2019 report, the QME stated that his conclusion of 3% of the applicant's 5% impairment was non-industrial and 2% of the 5% impairment was, quote, consistent with the described work activity. Now, the QME, according to the appeals board, did not in any way address the factors necessary that were accurately determine apportionment of the applicant's disability. And they cited the famous Escobedo versus Marshall landmark ruling. So regarding the PTP's initial report, the appeals board reiterated that the PTP in his March 2020 report concluded that he would apportion 50% of the applicant's disability to a 2010 slip and fall and 50% due to the CT industrial injury. Although the PTP stated his conclusions as to the apportionment, he did not provide any explanation and or any analysis supporting the conclusion. Therefore, the evidence was not substantial, and there's where the judge had a problem. The appeals board also noted that neither doctor, the PTP or the QME, provided any medical records pertaining to the applicant's 2010 slip and fall injury. As such, the doctors were not given an accurate factual history relevant to whether or not Mr. Amaro had any pre-existing disability caused by the 2010 slip and fall. So they concluded that neither the report from the PTP or from the QME constituted substantial medical evidence regarding the issue of apportionment. They go on to state that any award or order or decision of the appeals board must be supported by substantial evidence. And they went even further. They said the burden of proof rests on the party or the lien claimant holding the affirmative of the issue. In this case, it's Labor Code Section 5705. Here, they point out that the employer has the burden of proof to establish apportionment of permanent disability to a non-industrial factor or a previous industrial injury with substantial evidence. They finally say that the defendant carried that burden of proof on apportionment. And as he discussed above, the trial record did not contain substantial evidence addressing that issue. Why? Because they didn't have the facts presented before they made their apportionment decision until after they were given additional medical records. So the defendant in this case did not meet the burden of proof according to the appeals board. Now, in their conclusion, the appeals board did agree with the original workers' compensation administrative judge that as to the issue of the whole person impairment and permanent disability, the reports from the PTP were more persuasive than those of the QME and based the applicant's overall orthopedic permanent disability to be rated at 45%. So under those circumstances, it was appropriate that the applicant, Mr. Amaro, be awarded 45% permanent disability. They also mentioned that they find that the 45% permanent disability, there was no apportionment of the applicant's orthopedic disability, and that the defendant didn't meet the burden of proof regarding apportionment. So the decision after the reconsideration by the appeals board was affirmed, and the case was reviewed and overturned in issues of apportionment. Understanding, though, this is important because, as we see here, the PTP and the QME both provided their argument. However, we have that term that comes up many times, very often, in the substantial medical evidence realm of persuasiveness. And the Workers' Compensation Appeals Board found that the PTP's argument and conclusions for apportionment in this case were more persuasive than the QME's, and they went with his. Once again, and in conclusion, we have a QME's report that doesn't qualify as substantial medical evidence. We find that appeals board ruling increased Mr. Amaro's disability award from 23% to 45%, representing a substantial amount of money for Mr. Amaro. And he wouldn't have been entitled to had it not been for the appeals board's reconsideration ruling. This is just another example of the high stakes that we as QMEs potentially deal with in each and every QME evaluation and our QME report. So once again, doctors, I'm Dr. Chris Rapoff, and I wanted to thank you for taking the time to join me in this presentation. I hope you enjoyed it, and I look forward to talking with you and sharing some more important and interesting cases with you again soon. Thank you.